Okay, Madam Chair, we are live. Madam Chair, are you there?
Yes, I'm sorry, just give me a moment. All right, everyone, good evening, everyone. Welcome to the City of Paterson's Planning Board meeting. And would everyone please rise for the flag salute? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. I am missing something here, just bear with me one moment. Marianne, can you read, because I don't have that paper here. Or can I have,
Madam Chair,
I'm sorry?
which paper?
Wait, hold on, give me just one more minute. But I had it here. I have it, when was this meeting published, by the way? Was it published?
Yes, it was. Hold on one second, I'm sorry. It was republished. Hold on one second. I'm sorry.
And it was republished, yeah.
Sorry, the paper. I didn't have the paper readily available. My apologies. On the 20th, Madam Chair.
Okay. Okay, so commissioners, planning board staff, ladies and gentlemen, as chairwoman of the City of Paterson's Planning Board, I call this meeting of 11/30/22 to order. I hereby state that all the provisions of the State of New Jersey public meeting law have been fully and completely met, that the notice of provisions required have been properly posted in the planning board office and with the City of Paterson clerk, that the public notice and advertisements have been published in the Herald News, republished actually on 11/20/22 in accordance with the law, and that the copies of such notice and public advertisements are on file in the planning board office, as is also the agenda listing the applications to be taken up by the planning board at this meeting. Procedures tonight will be in accordance with the rules, regulations, and bylaws as heretofore determined by the planning board at its office in the municipal complex in the City of Paterson. Roll call, please.
Commissioner Ahmed.
Present.
Commissioner Hassan.
Present.
Commissioner Figueroa.
Present.
Commissioner Hussein.
Present.
Commissioner Vidanzo.
Present.
Commissioner Roman.
Present.
Commissioner Amar.
Present.
Madam Vice Chair Santana. And Madam Chair Norman.
Present.
Thank you.
Okay. Notice pursuant to the Open Public Meetings Act addressing the effect of the coronavirus measures on the next public meeting, which would be this evening, consistent with the coronavirus-related restrictions of Executive Order Number 107, given on Saturday, March 21st, 2020, by Governor Philip D. Murphy. The Planning Board of the City of Paterson will not conduct in-person participation of the public at all future meetings until further notice. However, public participation will be available by means of communication equipment pursuant to NJSA 10:4-8, commencing on April 15, 2020. Though there may potentially be a practical need for a limited number of administrative, technical, or other city personnel to be present in or near the council chambers, 3rd floor, City Hall, 155 Market Street, Paterson, New Jersey, In-person participation of the public is prohibited. Nevertheless, for reasons of compliance with the said Executive Order Number 107, public participation will be available by calling 973-321-1579, and the meeting ID is 3158 for this evening. I will repeat that later on. The date and time the meeting is scheduled to commence, which is this evening. The public may also participate in the meeting by accessing the website of the City of Paterson, www.patersonnj.gov, following the email link for the meeting, www.patersonnj.gov. So, we're here again. This is the second part of the Garrett Mountain Homes LLC 36-60 Mountain Avenue, Block 5103, Lot 11.01. If I'm not mistaken, and I remember Mr. Guzman, where's Mr. Guzman?
He's with Mr. Evans.
I'm here with Mr. Evans.
Oh, okay. So, you were representing, this, application, correct?
Yes.
Okay. I believe there is some issue this evening. Mr. Aquaviva, would you like to elaborate?
Thank you, Madam Chair. First, I know Mr. Guzman has entered his appearance on behalf of the applicant. Mr. Berglione, I see you are here. If you can enter your appearance and who you are appearing on behalf of, please.
Thank you very kindly. Good evening to all of your honors, Mr. Aquaviva, and members of the public. My name is Albert Buglione, Buglione. I am the borough attorney, or as they say in South Jersey, the solicitor for the borough of Woodland Park. It's a contiguous municipality next to the city of Paterson, and I'm representing the borough as an objector to the present application.
Thank you, Mr. Berglione. So, Commissioners, Madam Chair, just by way of summary, Mr. Berglione has raised several issues, one of which I'm recommending or is resolved. Will remain the remaining issues for later. But, Madam Chair, based upon issues that have been raised, you are going to have to recuse yourself from this application. So before we go further, if you can put on the record that you're recusing yourself from this application.
Yes.
Okay, I am advising you that, thank you. I am advising you that you cannot discuss this application with anyone, and in particular, the commissioners of this board, from this point further or until further
Right.
notice. Is that understood?
Yes, understood.
Thank you, Madam Chair. If you can, you're free to log off if you want to.
Thank you.
Okay.
Mr.
Commission,
Berglione, I'm
Yes.
sorry, also for the record, Mr. Cavallari is also here.
oh, I didn't see him. I'm sorry, Mr. Cavallari. Can you hear me?
Yes, I can.
Okay, I'm sorry, I didn't see you there.
I'm
The
gonna log off.
screen is all filled up. It's one of those things where I have to go to the next page at this point, so you must have not made it to the first page. I apologize. Madam Secretary, what we need at this point is a motion to appoint an acting chairperson for the remainder of this application. Can we have, is anyone prepared to make that motion?
This is Commissioner Figueroa. I'd like to make a motion for the vice chair, Ms. Santana, to serve as chair for the remainder of the meeting.
Thank you.
I need a second.
Second.
Was that you, Roman?
Yes.
Before.
Thank you. Commissioner Ahmed?
Yes.
Commissioner Figueroa?
Yes.
Commissioner Hassan?
Yes.
Commissioner Hussein?
Yes.
Commissioner Idanto?
Yes.
Commissioner Roman?
Yes.
Commissioner Amar? Commissioner Amar? I will come back to that. Vice Chair Santana? Yes. Commissioner Amar, are you still here? I think I lost.
Yeah, no, I'm here, but I was muted, I'm sorry.
Okay, Commissioner Amar, thank you. Okay, Madam Chair, you may go ahead.
Thank you, Madam Secretary. Mr. Berglione, you have submitted a letter brief yesterday and a supplemental letter brief today, which I have reviewed. You've raised a few arguments. So it's your motion. Why don't you make your presentation, and then I'll hear what Mr. Guzman has to say, and then we'll move from that point.
Thank you very kindly. Good evening again, Your Honors. My name is Albert Buglione. I am the applicant for a motion. The motion had two parts. The first motion was to recuse a board member. And the second part of that motion, and more importantly, which I will present to Your Honors right now, is to dismiss the present application without prejudice so that it can start anew. The basic.
Mr. Buglione, not to interrupt you, but we don't need argument on the recusal issue because Ms. Northrup has recused herself. So that issue is resolved. We can deal with your other issues moving forward.
There's a little bit of overlap, so if you
Okay,
feel I'm
okay,
repetitive,
understood.
please tell me. The actual connotation for the recusal motion was that the disqualified member had two separate conflicts. One conflict against my law firm. The second conflict involved a relative of hers having a dispute with my client, the Borough of Woodland Park, and that dispute was well known and involved potential for money damages. That just came to my attention today after my client reviewed my initial application, and I alerted Mr. Aquaviva immediately about that, which is my duty and obligation, and I submitted that in writing. Therefore, the issue that we present to Your Honors is that the municipal land use law specifically provides that no member of a board shall be permitted to act on any matter in which he or she, either directly or indirectly, has any personal or financial interest. In the instant matter, the former chairperson had a conflict and made multiple rulings relative to evidence in this case. And that involved handling of experts, questions for experts, previous motion to dismiss without prejudice. And since that person was conflicted, the law of the state of New Jersey provides that there is the potential for the entire matter to be tainted. It does not matter if it is tainted or not. The law provides if there's a potential for the public to view this matter as tainted, it must be dismissed and start over. And those are tenets from the municipal land use law, New Jersey statute 40:55D-69 and 40:A:9-22.2. The training that board members receive from the Division of Local Governmental Services, the manuals provided by the Division of Local Governmental Services, multiple other statutes which provide the maintenance of public trust in municipal government is the focus of statutory ethical codes, guided by common law principles that planning and zoning board members cannot hear cases where a personal interest might reasonably be expected or seen to impair their objectivity or independence of judgment. And that's a statute passed by our legislature at NJSA 49A:9-22.5 subpart D and NJSA 40:55D-69 and NJSA 40:55D-23 subpart B. It continues. The ethical commandments and guidelines involved in a motion for a disqualification, when found to be valid, require that a matter be started anew, and that is citing a recent New Jersey Supreme Court precedent known as Piscatelli versus the City of Garfield Zoning and Planning Board. That is a keynote case at 237 and J 33-219. Therein, our Supreme Court stated, in essence, the conflict of interest provisions of the law have been interpreted as a codification of the common law principle that a public official is disqualified from participating in judicial or quasi-judicial proceedings in which the official has a conflicting interest that may interfere with the impartial performance of the duties of the member of the public body and may be perceived as being not impartial. That is the keynote. It's not whether or not there's a conflict that exists. It's not whether or not there was a decision that was made that will impair. It's whether or not the public can perceive there is some lack of impartiality. And that gives rise to state and constitutional protections to the public, which are your citizens, as well as my citizens. the citizens of the city of Paterson, and the citizens of the borough of Woodland Park. And those are due process and equal protection rights, that every citizen shall have a fair, impartial, and unbiased tribunal reviewing their case in controversy. Here you're going to be making decisions that are going to affect the lives of a multitude of your citizens which reside in this general area. If there's any specter of impartiality, their rights have been violated. As such, there's further case law, which I've cited to Mr. Aquaviva on notice to the applicant, as well as to Mr. Cavallaro and to Mr. Joy Deutsch in his position as the planner, Wysocki versus Rizak, which is also another New Jersey Supreme Court case, precedent of nearly 30 years, and that goes into the evaluation of the common law test for conflicts of interest. Here it's been found that there is a conflict, so the member has recused themselves. So now we have to look at that impartiality, and I would submit to you that the painstaking detail that has been provided by the municipal land use law, your independent training, the Division of Local Governmental Services, and the case law provides that this matter must be dismissed without prejudice. Continuing with the case law. The overall objective of conflicts of interest laws are to ensure that public officials provide disinterested service to their communities, and most importantly, to promote confidence in the integrity of governmental operations. That is another Supreme Court case that's occasioned out of Atlantic City, known as Thompson versus Atlantic City, 190 NJ 359 at page 364, 2007. There are a number of distinct laws and sources that are utilized for determining conflicts of interest, which, as I've stated, the local governmental ethics law codified at NJSA 48:9-22.2, the municipal land use law at NJSA 40:55B-69, and the common law, which is now codified in those conflict statutes and still guides us. And the common law is just the creation of laws since the time that our constitutions were developed, as early as 1795, and for New Jersey, going back to 1947 and its predecessor, the common law. Furthermore, these conflicts have been codified and adopted by recent Supreme Court precedents, as I cited Piscatelli. The page to codify is at 350, and Grabowski versus the Township of Montclair at 221, New Jersey, 536, 552, at year 2015. As we continue, the overriding principle that I would submit to you as part of the municipal land use law is whenever the public perceives a conflict between the private interests and the public duties of the governmental officer and employee, the competence of the entire system is imperiled. That's at NJSA 40A:9-22.2, subpart A, subpart 2, subpart C. This has also been interpreted by our Supreme Court in Piscatelli, where they state that when the competence of the system is imperiled, the court must return anew to a de novo or a rehearing of the entire matter. And that was on a Piscatelli matter. And Piscatelli is very important. It was out of the city of Garfield. It had two of its most model citizens who unfortunately have recently passed away, Dr. Kenneth Conti and Dr. Keith Conti, who the board perceived did not have conflict. The board denied the application. The law division denied the application. The appellate division denied the objections. However, our Supreme Court has enunciated all of these new standards to state that the mere appearance of impropriety or the downgrading of the public confidence in our system of government requires that the matter be dismissed and started anew. Furthermore, cases cited by our Supreme Court and our Justice Radner in the Piscatelli case were Wysocki, which I cited before, and Bonitali, which is a case from 1951, which is still standing law and precedent that state no chance can be taken when one can perceive a violation of the public's trust in its duty to perform its perfunctory functions. Therefore, asserting that whenever there is a question of doubt, the error on the side of caution is to dismiss and start anew. There are a plethora of other cases on point for this. And as we move forward in the analysis, your honors are guided, I submit to you respectfully, by New Jersey's Code of Judicial Ethics, which provides when there is an issue involving the integrity and the competence of the judiciary, it is the obligation of the judiciary to protect the public's rights and their confidence in the system. Here we have a disqualified member, I submit on 2 grounds, who made substantial decisions as the providing owner and as your chairperson on a number of sensitive issues, sensitive legal issues, and whether it's perceived or not perceived, there is definitely a conflict which has been acknowledged, and the appearance of impropriety required the disqualification as well as a dismissal to start anew. And that comes from an additional case of, that has been developed by our Supreme Court called the Knight versus Cupo, 196 NJ 502, 517 in 2008, where it states the recusal and disqualification requires that the court start anew. That is in the judicial canons at Canon 3, Section C, Subpart 1. When a disqualification occurs, in all reasonable instances, to provide for a fair and unbiased hearing or judgment, which would lead to restoring the confidence of the public, the matter should be decided anew, especially in light of objections or issues brought to the attention of the court. Here, the objectors are following the procedure. We have brought this to the attention of your counsel immediately upon learning both of these conflictual issues, which occurred after the first hearing. So we had a full hearing where the applicant has presented 75 to 85% of their case. They presented an opening statement. They presented 3 full experts, and they started the testimony of their 4th expert. Therefore, a substantial amount of this hearing has been presided over by the chairperson with the conflict. And the doctrines that I have cited most certainly require that this matter start anew. There's also an appellate division case which is relied upon by Wysicki and Van Tally. Van Tally could not, this was decided after Van Tally, so it's not Van Tally, it's Wysocki and Grabowski. A conflict of interest arises whenever a public official faces contradictory desires tugging at him or her in an opposite direction, requiring disqualification and a renewal of the matter. These are not discretionary decisions. I submit to you that the precedent that has been decided by Piscatelli is a directive from our Supreme Court where a conflict of interest has been acknowledged and a board member has been recused. The only just and proper way to proceed is for a dismissal without prejudice. And there is more case law that I will wind down with until we have further discussion. There is a case, it's an unreported appellate division case, but I state that it's substantial for our analysis. It is called Kelly versus Baldwin and the City of Elizabeth. In that case, multiple City of Elizabeth municipal employees were suing the mayor and City of Elizabeth. The judge who was presiding over the case had relatives who worked for independent agencies affiliated with the County of Union and the City of Elizabeth, not directly employed by the City of Elizabeth and not directly having a contract with the City of Elizabeth. And our appellate division, relying on Piscatelli, said, where there is the perception that there's no impartiality, there wasn't a finding of impartiality, the perception of impartiality, the remedy is to overturn the decision of the judge, remand the matter for a brand new matter, and to assign a brand new judge when that matter is remanded. And I will submit to you that that is substantial and important because although this matter hasn't gone to conclusion, substantial decisions have been made 75% of the way through, and the binding directives by Justice Radner in Piscatelli constrain us in this particular matter to dismiss without prejudice and starting it. And with that, Mr. Aquavila, I submit for any questions. I reserve for additional argument, depending on what is stated by the other attorneys, yourself, or any member of the public on these vital and important issues of public integrity.
Thank you, Mr. Viglione. So
Thank you,
basically, I want to just summarize, if I may. You have essentially a two-pronged motion here, one of which has already been decided, and that is the recusal of the chairperson, and that was based solely originally upon the fact that you are representing an adversary to a lawsuit that the chairwoman is a party to, correct?
That is correct. That is factually correct.
Now, the second part of your motion, which came to my attention today by you, and I appreciate you getting the information over to me as soon as you can, is, if I understand your argument correctly, and the progeny of cases that you cited, essentially, because the application has been started, and the chairperson with the conflict presided over the first meeting on this matter, made certain decisions in this matter, and according to you, I'll hear from Mr. Guzman, I don't know if it's 75 to 80% complete, but it certainly has been started, and it has certainly gotten beyond the starting point, I'll give you that. So your argument is basically that because of that reason, the application should be started anew with a new chairperson sitting in from the very first words that are spoken on the application, correct?
That is a wonderful summary and synopsis of what I was attempting to state.
Okay. Mr. Guzman, I'm sorry, before I get to Mr. Guzman, Mr. Catalar, I know you're representing an objector as well, or I should say an interested party as well. Do you want to be heard on this motion?
Not other than just joining the motion. I think Mr. Guglielmo did a great job arguing the motion. My client, which is Garrett Heights Condominium Association, a neighboring condominium association, certainly joins in that application and agrees with the position set forth.
Okay, thank you. Mr. Guzman, do you have anything to say in response?
Thank you, Mr. Aquavito. Well, one of the issues I have is obviously the late notice of the motion and my inability to actually respond in any way. I don't believe that the board has sufficient information to be able to go forward and make a decision. As you're aware, the letter and correspondence that was submitted today did not have any sworn statements, no certifications, nothing of that matter. We've heard a lot of law, and of course, there's no shortage of conflict cases in the state of New Jersey at all. However, in terms of actual facts, sworn statements, we don't know anything that occurred. And so, for two reasons, I don't have an opportunity to say or contradict anything that was submitted in the letter. B, there's no factual information in the letter other than second, third, or fourth-hand information. I surmise, because I have no idea. It was just a general overview of this happened. We have no idea if it was the nature of the discussion. We have the prism or lens of Mr. Boglione who's saying this is what happened, but we don't have any sworn statements. And so the board today doesn't have enough information to be able to proceed and make a decision on whether this should be dismissed at all. To go back to the question of whether how much of the case I had presented, the lion's share had been presented. I did have Mr. Williams ready to testify some more. I had individuals ready to rebut, and I understand that Mr. Cavar had and Garrett Heights obtained a professional to testify today as well. But the reality is, these applications were made at the 11th hour. Our meeting date was September 19th. And so everyone's at a substantial disadvantage and another waste of time that has occurred between now and then. And, it's the conflict with respect to the chairwoman regarding Mr. Boglione's representation of the county. Well, that was September 19th. And so here we are receiving she didn't know. I'm not sure she knew. You know, there's no information to go off of in that regard. There's no information to say that any of the decisions were tainted with the bias that the objector claims. And so, if he didn't know she was an adversary in proceeding, there's no information today that says that she knew. So it puts the applicant at a significant disadvantage, despite the 1 year plus that this has been going on. So, for all those reasons, I don't believe that this is the forum to actually make that decision regarding if this matter should be dismissed.
Thank you, Mr. Guzman. I guess, and I understand what you're saying entirely, but it raises two significant points. First, I don't think it really matters whether or not the chairwoman knew or didn't know. The fact remains that I think it is undisputed the first part of Mr. Buglione's motion, for lack of a better term, would have been granted. There was certainly a conflict of interest between Madam Chairwoman and Mr. Buglione's firm representing the defendant, the defendant in that application. Raises another, your argument raises another significant question. You didn't have time to respond to this motion. You didn't have time to submit any paperwork or any documentation in response. Do you want the ability to do that? Because, and I hear from Mr. Buglione again, and you can table that if you want to think of that for a little bit, and I will hear from Mr. Buglione again, unless you have an answer for me. Do you want to submit paperwork in response to Mr. Buglione's motion so that this board can make that decision? Because in the last part of what I heard from you, and correct me if I'm wrong, you had indicated that you don't believe that this is the proper forum for the board to make that decision. And I don't necessarily disagree with you, but I want to know if you want to submit any documentation in response before we get to making that decision.
I don't believe Mr. Buglione submitted a letter brief, and while I don't believe there's sufficient factual information there, there's a lot of legal information that was provided. And I'm not sure it's within the purview of the board to make those decisions. So I do believe that the ultimate form would be the Superior Court, and that an emergent application should be made by the objector.
I tend to agree with you, and I do agree with you on the first point you just made now. Mr. Buglione made a very well-articulated argument and submitted documentation in support of that argument and raised issues, but again, did not submit specific certifications as to the conflict, the circumstances surrounding any type of inappropriate discussions between the chairperson and boroughs of Woodland Park. But I'm not sure he is obligated to do that right now, to be honest with you. But that is a valid point. Mr. Buglione, if you have anything to say?
Yes, first and foremost, I think we can cut right to the chase if you ask the chairperson if she's related to that individual.
Well,
I know that builds the factual information to remove all doubt from the applicant, because the applicant.
Let me interrupt you 1 second, because that would go to the point again that we've already addressed it.
Yeah, so I can address
There's a
it.
conflict of interest, no two ways about it. Madam Chair recused herself. Not even a question. What it comes down to is whether or not the application needs to be dismissed and restarted again. That's the issue before this court. The reasons behind it, fine, we can get to that. But the sole issue before this board right now is whether or not this application needs to be dismissed without prejudice and restarted again in the future. On that point only, do you have anything further to add?
Yes. I would state that the Piscatelli doctrine that I have submitted to you is binding on this board, because we've already established the prima facie showing that the board member needs to be recused. In Piscatelli, that wasn't established. That had to be decided by the court first. Then what occurred was the Supreme Court said, once you establish that there is a prima facie conflict of interest, the matter needs to be started. And that's the directive. And furthermore, the Supreme Court was very disappointed in that board for not making findings of fact, before remanding it, return the matter for findings of fact, and that's why I made my statement. Most unfortunately, the applicants in that case have passed before the case was resolved. Due to COVID and whatnot, those hearings have been dragging on, there are further appeals. So the applicant actually has more control in this case than the applicants, the applicant, for longer than to read the thorough opinion, gave the applicant the opportunity to withdraw their reply or consent to the dismissal and start anew. And if they had, the matter would have probably been resolved. Because you wouldn't then go to the appellate division of the Supreme Court, a remand, then a rehearing, and then an interlocutory lift up as an appeal from the actual hearing where they were. So that's 5 years of litigation. I think that we're being very fair. I notified everyone as soon as I learned about these conflicts of interest. I'm aware, and there are other cases that state where an objector waited till after the case and used the conflicts as a trump card, and the courts were disappointed in those attorneys, but that said they had a rule for a reversal to protect the public. And that's the big point that I want to stress. It's not about the objector, it's not about the applicant, it's not about the board, it's about the public. And that's exactly what Piscatelli said, and Piscatelli said it's a due process right and an equal protection right, and you don't get any stronger rights than due process or equal protection under both our state and federal constitutions. So it's the rights of the citizens that need to be protected. And I would submit the board can be constrained to follow Piscatelli, dismissed without prejudice. Then if the applicant wishes to bring it up, let the applicant bring it up. But I've proven the first prong, which is the most difficult prong, that there's a conflict of interest.
Thank you, Mr. McMillan.
I'm sorry,
Yeah,
this is Commissioner Figueroa.
Yeah.
And if I may, Madam Chair, could I ask a brief question? I don't mean to interrupt any of the attorneys that are.
Commissioner, if I could just finish this one thought that I want to get out, and then you can say whatever you need to say, okay? I just want to address one point. Unfortunately, Mr. McMillan, I'm familiar with that last progeny of cases that you just that you just recited. So I understand where you're coming from. All right, Commissioner Figueroa, you had a question.
It's just brief. You are, there is citing of case law, as a layperson, because I'm not an attorney, and with all respect to all parties involved, and I'm just speaking for myself, I don't speak for the other commissioners, but there's a lot of case law that you're citing. There's comments about judges being disappointing, boards being, like, it's a little bit overwhelming. Not that I'm not following, but it's a lot of legalese. And I believe that, it's just, is there a way to get this adjourned so we can find out more information?
Commissioner, that's a very good point,
And I'm sorry, I don't mean any
No,
disrespect. I'm saying, there's a lot of case law you're citing,
it is more than a valid point, and even more so, it's a segue into what I'm going to recommend to the board. Before I do that, though, Mr. Guzman, do you have anything else to add to this argument?
Only that one of the points Mr. Buglione made was, and it goes along with what Commissioner Figueroa was saying. In one of the cases, he described how it was denied by the board, denied by the Superior Court, denied by the Appellate Division, and then ultimately resolved by the Supreme Court. It's difficult, complicated law that we're dealing with at times, and I understand Commissioner Figueroa's concern in this, and it goes to my suggestion that this matter be heard by the Superior Court.
Thank you. Madam Chair, Commissioner, this is going to be my recommendation to the board, and Commissioner Figueroa brought out a very good point, and Mr. Guzman's argument in a practical matter is very relevant. My job as the board attorney is to make sure that these meetings are conducted in an expeditious manner, in a efficient matter, that applications are to be decided in an expeditious manner thoroughly, but expeditiously. The last thing that I want to see happen with this board is to have an application that drags on for 6 months, a year and a half, and some of you may shake your head, they absolutely do drag on that long sometimes. And it's not expeditious, it's not efficient, it's just not a way that the board should conduct applications, even on a specific basis as opposed to a general basis. So my recommendation to the board is that this issue of whether or not the application should be dismissed without prejudice and started anew is more appropriately before the Superior Court in the Law Division. So my recommendation is going to be that Mr. Buglione have until January 15th to file a lawsuit for a judicial determination as to whether or not this application should in fact be dismissed without prejudice. If Mr. Buglione files an application, yes, everything will be stalled here until the judge in that case makes that decision. If Mr. Buglione for some reason does not file that lawsuit by January 15th, then this application will continue as it would have continued tonight. Certainly, Mr. Guzman, you have the opportunity, if you deem it beneficial, to withdraw the application and file it again at any given time between now and January 15th. That's within your discretion. You discuss that with your client. If that may be a better way of handling it, that's fine. What I do want to do, though, is, Mr. Deutsch, just for the sake of not having the applicant have to re-notify everybody, is there any date that we can schedule this for? Because obviously all bets are off. If Mr. Buglione files his lawsuit, then that date's not going to be, it'll be available for another applicant again. But my suggestion is, giving the full time period to January 15th, is there a date, say, as early as the first meeting or third or second meeting in February? Actually, is this a special meeting or is this a regular meeting?
Tonight's a regular meeting.
Okay, good. All right. So is there our first or third meeting, first or second meeting in February? Is that available that we can schedule this matter now so at least we can put on the record that this is, this is going to be carried?
Yes, just let me get my calendar.
The meeting dates are February 1st and 15th, Mr. Deutsch.
Okay. So while Mr. Deutsch is doing that, we can still call for a motion, and the motion would be to adjourn this matter to a time after January 15th, giving the interested party, the Borough of Woodland Park, the opportunity to initiate litigation no later than January 15th to determine whether or not this application should be dismissed. Without prejudice. That's the motion that would be that we would be calling for tonight, if that is the board's pleasure. Madam Secretary? Oh, there you are. Okay. So, I'm sorry, it was Mr. Deutsch. Mr. Deutsch, do we have the date?
Our regular meetings in February would be Wednesday, February 1st and Wednesday, February 15th.
Okay. So, I don't think it really matters because we're going to put it on the record, so there's not going to be any 10-day issues in terms of notification. So, the motion the board is so inclined. Yes, Mr. Buglione.
It's my understanding that under the municipal land use law and the public notice requirements, when a matter crosses a calendar year, all notifications are required.
You know what? You're right. I didn't even realize that we had.
No, I just want to be transparent.
No, and I'm glad you pointed that out. I was treating this as you're absolutely right. I didn't even realize we had.
No, I know.
It's
the end of the year. It's absurd.
Yeah, thank you.
Mr. Aguilera, I'm sorry, can I interrupt? These calendar dates were adopted at the reorg meeting in July, so these have been noticed.
Okay, so Mr. Buglione, our year runs from July to July, not January to January. So February 1st would be okay. Okay.
I think it has to be renoticed for the individuals because of the carryover. That's your determination. I just dealt with this issue once before. But it's your call.
To be honest with you, I don't
I know.
believe that's applicable, Mr. Guzman. I would put the onus on you to figure that out because I don't want to have your client
I don't want that
prejudiced.
responsibility myself.
So I'll leave that to you, Mr. Guzman. Thank you, Mr. Guzman. So, Madam Chair, what we're looking for is a motion to adjourn this matter to February 1st. And quite frankly, I will put on the record that Mr. Buglione has until January 15th to file litigation for the reasons that we put on the record tonight. And that's it. So it's essentially a motion to adjourn this application to February 1st.
So move.
Thank you, Mr. We'll
I think that was-
Let's make a motion. I think we done so.
Yeah, I think that was him.
Do we have a second?
Second.
Commissioner Roman?
Kabir Ahmed.
Ahmed, thank you. Commissioner Ahmed?
Yes.
Commissioner Figueroa?
Yes.
Commissioner Hassan?
Yes.
Commissioner Hussein?
Yes.
Commissioner Iranzo?
Yes.
Commissioner Roman?
Yes.
Commissioner Amar?
Yes.
Acting Madam Chair Santana?
Yes.
Thank you.
Okay,
Okay.
Mr. Webigot, there's anything else that you would like to add?
There's nothing else. I think we, what's that saying? The horse is dead. Let's stop eating it. It's done. So, no,
We're
we
gonna put it on
don't.
the record. I don't know, normally we put on the record no further notice, but in this case, I don't know.
I'm gonna put on the record that no further notice is, required as the notice was put on the record tonight. Again, Mr. Guzman, if you wanna look into this further and believe that there is a reason to re-notify for the February 1st date, do so within the statutory time period. Mr. Buglione doesn't file a lawsuit, we'll be back on this by February 1st. If Mr. Buglione does file a lawsuit, it's gonna be a while before we're back on this application.
Mr. Jacoby, if I could just be heard on one issue,
Sure.
just quickly, and it's only because, you said you're not requiring the re-notice, and it's a little bit different. I wasn't gonna make us think of it, because the matter's essentially being carried, but there is a little bit of, issue with the notice for tonight that was a little bit misleading, that I think, the reason I'm standing in City Hall, in the council chambers right now, is, I believe it said something to the effect of also, or maybe also be available via Zoom, which I think may have led some members of the public to believe they could have came in person, yet it was only, online. So because of that, I think it should be re-noticed, at this point.
And you know what, you bring out a good point, because we may very well be back in person after January 1st. I don't know. So, obviously, if we're gonna be in person after January 1st, it might be wise to re-notify, without the language about it being virtual. So, you know, again, these are one of those intangibles that unfortunately we're gonna have to deal with in this transitional period from being virtual and going in person. But, Mr. Guzman, would you have an issue putting on the record tonight that you would re-notify for this meeting?
I don't have any issues stating that I will be notified for the first meeting.
So even though we're putting on the record tonight that the adjourn date will be February 1st, there will be a requirement for the applicant to re-notify, and obviously don't do so until we actually determine whether or not we're going to be in person or not, so we can have accurate notice. All right, are we all on the same page?
I knew Mr. Calabar's office looked familiar.
What was that?
I knew Mr. Calabar's office looked very familiar.
I was about to say that looks real familiar to me as well.
I've got me and my.
Some virtual background there. All right, well, Madam Secretary, I think that's it.
Yeah, we don't have any further matters before the board.
Mr. Deutsch, do we have anything further?
We have a, special meeting Monday, December 5th, and a regular meeting Wednesday, December 7th.
Okay, got it.
Seeing no further, matters, I need a motion to adjourn.
So move.
I need a second.
Second.
All in favor?
Aye.
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 Have a good night, everybody.
Thank you. Good night,
Happy
everyone.
holidays. Thank
Happy
you very much.
holidays.
Happy New Year.
Bye.
Thank you so
Good night.
much, everyone. Good night.
Let's go, sir.
everybody.